Well, let's look at this now from both the legal and IEC perspective with legal expert Modidima Mannya and former IEC Deputy Chairperson Tselane. Welcome to you both. Thank you very much for your time. Modidima, it was an education in the law yesterday with sections 47(1)(e) and 19 setting the foundation for the arguments. And it seems as with the verses in the Bible, they can be variously interpreted. What did you make of those interpretations?
Well, I think to really contextualize this, we must understand the scheme of our constitutional framework. We have got three arms of the state: the judiciary, which is vested with the judicial authority. If you go to section 165 of the Constitution, it's very clear that the judicial authority vests in the courts. Now, nobody else can change a judgment or ruling of a court except a court. Then you have got the legislative arm, which is our parliament, which makes laws. So it made the law which the IEC must implement as part of the system. Then you have got the executive, which is headed by the president, who's given certain authorities and prerogatives. He and him alone, with his executive, can exercise them. So as we debate what Section 47 says, or doesn't say, we should say that in context of the entire constitutional framework that we operate in.
All right, so that's interesting, but those were the two pieces that were highlighted as reasons for why this argument for Mr. Zuma's unfair disqualification was predicated. One of those key arguments yesterday, Terry, was, did the IEC have the authority to do what it did? Was it correct in its interpretation of Section 47? Zuma's team believes they were not. What is your understanding of this?
Thank you very much for having me. I must say that I'm persuaded by the MK legal representatives in this regard. Firstly, Section 47 deals with membership of National Assembly, and it does refer again to a candidate for National Assembly. So National Assembly candidate is different from candidate in the elections. Essentially, candidate in elections involves 15,000 candidates who are there, who are contesting the elections, and for the National Assembly, it refers only to 400 members who are supposed to be participating. So before they are sworn in, they are candidates for the National Assembly. So the IEC did not really have the power, in my opinion, to exercise its authority over Section 47. That Section 47, it's a preserve of the National Assembly. And then also because, we tend to focus on only one aspect amongst issues that are contained within Section 47. Remember that there are quite a number of other exclusions. In other words, this includes every person who is an employee of the state, anyone who is a teacher, a civil servant, anyone who is appointed as a permanent member of National Council of Provinces, anyone who is in a provincial assembly. Now, this could not have meant that those people should be excluded from participating as candidates in the elections. But once these people are elected and they become candidates for the National Assembly, then they cannot hold the same two positions. They can't be a teacher and at the same time be a member of the National Assembly. And it is on that basis that the IEC, I think, erred in terms of applying Section 47. And then besides that, Section 30, in terms of which they're supposed to be adjudicating all the objections, only talks about three grounds. And one, it's whether a candidate is qualified in terms of the Constitution. And secondly, whether they have signed a declaration committing themselves to abide by the Code of Conduct, and whether they have signed the nomination form. Those are the only three grounds that they can actually use. So the issue of a constitution also does not necessarily refer to Section 47. It refers, for instance, to issues such as whether a person is 18 years of age, whether the person, is registered, whether that person is a citizen. And then all that information is in the preserve of the Commission, because the Commission is the custodian of the voters' roll.
I want to quickly then go to this, because based on what you've just told us, it sounds like you would also agree then with Mr. Zuma's legal team that the IEC function is restricted to Section 190, which says it should do three things: manage the elections, ensure they're free and fair, and declare the results. Is that as straightforward as Mpofu says it is?
No, absolutely. Those are the main functions of the Commission, to organize the elections, to make sure that those elections are free and fair, and to declare the results within a specified period. But obviously, that is not the only section that governs the functioning of the IEC. Section 181 also gives the powers to the Commission to perform its responsibility. And therefore, there are quite a number of provisions within the legislation, but it is absolutely not Section 47. Modidima, let me come to you on this next question. And it was so interesting, just the framing of all this, so adversarial, it was the battle of the legal minds and who won and so on. And perhaps if there's time, we can maybe deal with the theatre of court. But when Advocate Nlukaitobi says it's absurd, serious lawbreakers should not be lawmakers, and provided his interpretation of the various sections, from your perspective, did he deal sufficiently with the argument, do you think?
Yes, it makes sense. And I think, with the greatest of respect, I don't understand the basis of Mr. Tselane's interpretation. The Constitution could have never envisaged that an unrehabilitated insolvent finds himself or herself at the door of the National Assembly after an election, and thereafter you are told, look, you are an unrehabilitated insolvent, you are not allowed here. The purpose of the IEC is to register candidates and to register political parties. So they must incidentally register people who are eligible. Otherwise, we can vote for murderers, and only when, after the election, when they are supposed to take seats, then the issue of their murderous tendencies is raised. That is a dangerous proposition to make. I agree with Mr. Nlukaitobi. The Constitution is clear. It bars certain categories of people, not just people who are convicted, but unrehabilitated insolvents, people who are of unsound minds. That means somebody must check whether we should, in the first place, be voting for those people.
Well, let's then go to the issue of that disqualification, and there was quite a bit of argument on the sentence itself. And Modidima, maybe I'll kick off with you on this legal aspect, that, the idea of a civil court versus a criminal court, and whether a civil court can make a criminal finding. Then on the remission of sentence, where there's no outright pardon, even a remission of sentence which reduces the sentence time, which now falls under the threshold of ineligibility. However, him saying that it doesn't, kind of dissolve or make invisible the fact that there was a longer sentence. Just talk to us about some of those nuances, some would say they're not nuances, those are specific aspects of the law that is a threshold that you have to meet. And, what did you make of the way that Nlukaitobi framed that as an exclusion, as the reason for an exclusion?
Yeah, Iman, I think we can come with some theatrics around this issue. The bottom line in this matter is that somebody has been imprisoned, which is one of the requirements. And to be imprisoned, you must be found guilty of something. Whether you want to characterize that as a guilt of a civil or a criminal court, the sum total of it is that the court has found that Mr. Zuma was guilty of contempt of court, and it has imprisoned him. And now that, in my view, meets the requirements of Section 47. So to try and argue that there was no plea, in fact, we must take it further to indicate the correct set of facts, is that the court also invited Mr. Zuma to make representations, and he waived his right to make such representations. Now, the same applies. If you don't appear in court, you will be arrested. It's a normal practice. the courts have such authority. So I think that, trying to say this is a civil court judgment doesn't change the picture. Let me give this analogous example. In liquidation proceedings, if I get a judgment against you for a sum of 100,000, when the liquidators ultimately wrap up the estate, they could easily give me 10 cents in a rent. That does not mean the court order that said you owe me 100,000 has changed. It simply means what is left of what I'm owed or what can be recovered is 10 cents in a rent. Now, the same applies to this remission story. I don't understand it to mean it is a change of the judgment of the court. As I said, Section 195 is clear. The judicial authority is that of the courts, not of the president. When the president reduces, and the reasons for remissions and paroles and pardons are very clear. And remissions are given to people who are less of a risk to society, less aggressive offenses such as this one. Now, if Mr. Zuma qualified for a remission, and we then turn around and say this is not a criminal conviction, then he shouldn't be outside because he's not a product of a criminal conviction. Because then the argument must go further by parity of reasoning that a remission only given by people who are convicted by criminal courts. So he's having his cake on the one side and wanting to eat it on the other side. Doesn't work that.
Terry, I want your response on what Modidima is saying, not understanding the basics of your argument, saying that really it is the responsibility of the IEC to make sure the people who appear on the ballot have been vetted properly, that, all their hygiene has been followed so that the public doesn't have to bother about wondering whether, is someone eligible, are they not, have they been convicted of something, haven't they? That's all the job of the IEC. The voter just has to concern themselves with the names on the list. Your thoughts on this?
No, I think his interpretation is wrong. And then I'll tell you why his interpretation is wrong. If the IEC was laboring under a misapprehension that it's supposed to be dealing with Section 47 of the Constitution, it was not going to wait for objections to be raised. It was actually going to develop a report and do due diligence on each and every person who is supposed to be excluded, and then indicate that these are the people who have actually been excluded. And it does not do it because it realizes that this is not its responsibility. And then I also have got issues about trying to elevate one aspect within Section 47 as though it is supreme to all other exclusions that are there. And then we talk about murderous people and all that. Now, I have indicated the exclusions. I'm saying whether you are excluded in terms of your criminal record, whether you are excluded because of you've got unrehabilitated, you are regarded as unrehabilitated, insolvent, whether you are excluded because of unsound mind or having been declared by the court of unsound mind, or whether you are a civil servant or in the employ of state, those aspects cannot be excluding candidates in the elections. They can only exclude a candidate in terms of National Assembly. And I'm saying to you because all of them have got to be applied at the same time. If the IEC were to do that, it would mean that it would have to have firstly due diligence and check all the civil servants, check all the teachers, remove them before they even come to the issue of the elections. And I think it would be very absurd to have an arrangement like that. That's why the specific aspects of Section 47 deals only with National Assembly and membership of National Assembly. So what it would mean is that once a person has gone through the first hurdle, they get to the National Assembly, they become candidates for the National Assembly, then you've got to check, have these people been regarded as of unsound mind by the court of law?
Right.
Have these people been declared insolvent? And then again, I just want to give another example. Remember that recently we had a situation of Mr. Makwarela in Tselane, who was regarded as unrehabilitated insolvent, and he was a mayor of Tselane. Who dealt with that particular issue? That issue was not dealt with by the IEC. it was dealt by the city. The complaint was lodged with the city because for every level of government, there's got to be a mechanism to implement Section 47.
Right.
So at the level, it's got to be the city manager. At the provincial level, it's got to be the provincial secretary, the secretary of the legislature. And at the national level, it's got to deal with the secretary of parliament.
Modidima, I'm going to give you a chance just to come back on that particular point, and then I want to move on to two things before I end, saying that they should still be let on the ballot. When there is an issue of, going to the National Assembly, this hygiene process will be done, and it will be done differently, but it will be done.
Yes, I think let me correct Mr. Tselane. There are specific constitutional disqualifications. For instance, the issue of being a civil servant is not a constitutional disqualification. It's not there in the Constitution. The disqualification includes the conviction, being of unsound mind, rehabilitated, and all this. So I'm not sure what that is based on. So in terms, and we are not elevating any matters here, the Constitution is very clear about the disqualification of people who have been convicted of offenses 12 months. Now, without the option of a fine, you don't have to be a murderer. The murderer is just used as an example to aggravate the situation. But the bottom line is you ought to have been convicted and sentenced for 12 months without the option of a fine.
Terry, I saw you shaking your head vigorously, so I want to quickly sneak in maybe just a few seconds of your response to that, but I do want to move on to two other issues.
The difficulty is having a debate with a person who has not read the section. I've had to deal with this section for almost 20 years, and I understand exactly its provision. The exclusions are there, and it says, and that's how it starts, Section 47. It says all the people who are in the employ of state, they are excluded from this. And it says members of the provincial assembly, and it also says permanent members of the National Council of Provinces. And then after that, it will then include a person with insolvent record, a person with unsound mind, and a person with a criminal record. Those are the exclusions that are there in terms of Section 47. And if a person has not read it, it becomes difficult to debate with a person who has not read the section.
Okay. With your permission, though, I'm going to move on, and perhaps it's worth coming back to some of the issues that you're raising once we have, and we understand it's going to be a written judgment. This is happening at 2 o'clock today. But what the both of you are saying, very, very helpful in helping us just develop our understanding of the way things are going. I think the bottom line is, when you think about what Mr. Zuma said outside court, that he was recalled before the end of his term of office, not aware of anything barring him from leading another party, that democracy is about what the majority wants, including who leads. This has become, obviously a campaign of his is campaigning for the MK party, but also the characterization of his re-entry into politics in a very prominent role has been the subject of a lot of debate. Modidima, maybe to start with you, just with the way, again, the framing of all of this, in a sense, as, Dali Mpofu said, and I didn't put the quote here, but basically, saying and reinforcing the idea that the IEC or the court is looking for a way to kind of scapegoat Mr. Zuma, prevent him from reaching the office that he wants to reach. Let me just quickly find that. I have it written down here, and I think it's important. No, when you have a lot of pieces of paper on your table, you're not going to find it. But that was how he was framed, as somebody who's still persecuted, as somebody who is being denied being available to serve the people. Just your thoughts on that. I know it's slightly outside the realm of legality, but your thoughts on that.
Well, it's within the realm of legality, because in a constitutional state, if Parliament makes laws which are found to be constitutional and they impose certain obligations or restrictions, those laws must be complied with. I think the real issue here is whether, on correct interpretation, Mr. Zuma qualifies at two levels. Firstly, having served 2 terms, whether the correct interpretation should be, for that reason, is excluded. And secondly, on the issue of the interpretation of his conviction and sentence. So I don't necessarily think anybody is going out of their way to prevent anyone from contesting the elections. For instance, there are people who have said that they were going to contest the elections, And they have not met the requirements, because there are requirements. You'll recall that certain parties had taken the IEC to court with regard to the 15,000 signature story for new entrants in the game. And the court ruled against them. But let me, as I'm still on the platform, correct Mr. Tselane. There's a difference between people who are appointed in the service of the state and people who are employed in the state. There's a big difference between the two.
All right. Thanks for that. I want to bring this then to you, Terry, maybe also as the final word on this. And I found the quote, by the way. It was by Dali Mpofu. The attitude of the IEC has been, let's see where we can catch him and where we can let him not get out alive, which reinforced this idea of him being sort of a target. For me, the important thing, Terry Tselane, is what we've been talking about in the lead up to this election around the credibility of the IEC. Seeing this battle go to court, IEC and MKP, where do you think it leaves that, especially in a year that, for all intents and purposes, has been billed as the most important election since democracy?
The IEC is still a very credible organization. There are teething problems in terms of management of these elections, some minor mistakes here and there, but I don't think those mistakes should actually be elevated to the extent that we can say that it has lost its credibility. The issue of taking the IEC or any person to court is something that is available in legislation, that if a person is aggrieved or dissatisfied with the decision of the commission, they can raise those issues in the Electoral Court. And I think it does not mean that the IEC should lose its credibility on the basis that it has actually lost in the Electoral Court if they lose this particular aspect on the basis of misinterpretation of a particular or application of a particular provision within the law. And I think going forward, they also need to know that these elections are going to be complex, difficult. They've got to do everything to make sure that they jealously guard that credibility and integrity of the institution, so that their decisions are not questioned and their intentions are also not questioned.
Legal expert Modidima Mannya and former IEC Deputy Chairperson Terry Tselane, thank you very much for being on our program and for sharing your insights. Mentioned earlier that ruling, that judgment expected at 2 p.m. today, and we'll certainly bring it to you as soon as we receive it.